Hello and welcome back to the channel. Today we're going to go off topic just a little bit. A few people have asked me about preliminary hearings, what they are, what their purpose is, and how they work. So let's go over that today. In some states, a preliminary hearing can take place only when felony charges are present and the defendant has entered a plea of not guilty. This happens most often in areas that do not use a grand jury to bring indictments. Prelims are not always required, but when they are, the defense can opt to waive it. The point of a preliminary hearing is for the prosecutor to prove to the judge that there is probable cause to charge the defendant and that the evidence warrants going forward to trial. A preliminary hearing is not a trial, but a legal step in the process of getting to trial. This hearing is not held to determine if the defendant is guilty or innocent, but simply to determine if there is enough evidence to back up the charges and warrant putting everyone through the process of a criminal proceeding. In a preliminary hearing, the prosecution can call witnesses and present evidence to the court. The defense can cross-examine the witnesses if they so choose. Information and testimony can be presented during a preliminary hearing that would not ordinarily be allowed in a formal trial, such as hearsay evidence, although non-expert witnesses are still only allowed to testify about what they perceived, not give their opinions. In most cases, the prosecution has not yet turned over the full body of discovery to the defense, and they may choose to play their cards a little close to the vest and only put forth enough information to convince the judge that the trial should proceed, without giving away their entire strategy for the trial. However, the prosecution has to present any exculpatory evidence to the defense at this time if the defense has asked for it. If the case proceeds to trial and it is discovered that the prosecution had exculpatory evidence that was not turned over at the preliminary hearing, that could be grounds for dismissal in most cases. The burden of proof for this type of hearing is not beyond a reasonable doubt, but instead probable cause, similar to the information that we would see in a probable cause arrest affidavit. What will be presented is far from the totality of evidence that the prosecution holds, but just enough to convince the judge. The most common types of witnesses we see in preliminary hearings are police officers and investigators. However, a prosecutor may elect to call witnesses that seem reticent to testify, or ones that might be ill, because they would want to get their testimony on the record as fast as possible. Any testimony presented in a preliminary hearing is then admissible later on in the formal trial. The defense can also present their case and ask for dismissal if they think they have evidence to support that. There are three possible outcomes for a preliminary hearing. 1. The judge rules that there is probable cause and the case will proceed to trial. 2. The judge could reduce the charges from a felony to a misdemeanor or even less serious felony charges. And 3. The judge can rule that there is not enough evidence for the charges and the case could be dismissed completely. If that happens, the prosecution can refile the charges at a later time. So, that's the basics of a preliminary hearing, and that's what we're going to see on August 3rd and 4th for Chad and August 10th and 11th for Lori. Monday afternoon at 2:30 p.m. Mountain Time or 3:30 p.m. Central, we are going to see a hearing, but it is not the preliminary hearing. This is a hearing for both sides to argue whether or not cameras should be allowed at the preliminary hearing. And we also have a third party thrown into the mix now, as attorney Steve Wright has filed a motion objecting to Rob Wood's motion to ban the cameras on behalf of local and national media organizations. So, Monday afternoon's hearing is going to be pretty interesting. I do expect that one to be televised because the standing order from Judge Edens is to stream these hearings to the public. So I will bring you that hearing live as it happens Monday afternoon. Make sure you hit the notification bell below so you don't miss it. So tomorrow I'll be doing a live stream with a weekly roundup of all the news in the case and a casual conversation with viewers. So please join, those are usually a lot of fun. And Monday afternoon I will see you live about 3 p.m. to watch the hearing about cameras in the courtroom. What's your opinion about cameras in the courtroom? I'm for them at this point because most preliminary hearings are public. If Rob Wood does not want these to be public out of fear that they may contaminate the jury pool, then I would have expected him to ask for these hearings to be sealed or closed. But he hasn't asked that. So perhaps this is a legal maneuver in order to force the defense attorneys to both go on record stating that they want cameras in the courtroom, which would prevent them from using that the jury pool was tainted later on in future arguments to ask for a dismissal or a mistrial. So it could be just clever legal maneuverings. We're going to have to wait and see. If you're looking for more information on this case, please join us in Discord. There's a link in the description below, and Discord is completely free to use. I have all the documents that are available in the case up there, as well as round-the-clock lively conversation about this case and everything else under the sun. You can also join my Patreon, where I have a lot of deep dive videos looking at different aspects of the case that may be a little too controversial for the main channel. So join us there, and I hope to talk to you soon. Until then, stay safe, friends, and I'll see you tomorrow.